122 Gift defined. Gift is the transfer of certain existing movable or immovable property made voluntarily and without consideration by one person, called the donor, to another, called the donee, and accepted by or on behalf of the donee. Acceptance when to be made. Such acceptance must be made during the lifetime of the donor and while he is still capable of giving. If the donee dies before acceptance, the gift is void. This passage defines gift under Section 122 of the Transfer of Property Act, 1882. Let's break it down. Key elements of a gift. Transfer. Ownership of existing property, movable or immovable, changes hands. Voluntary. The giver, called the donor, acts freely and without pressure, without consideration. The receiver, called the donee, receives the property for free, with no exchange of money or anything else. Acceptance. The donee must explicitly or implicitly accept the gift during the donor's lifetime, while the donor is mentally sound. Void if not accepted. If the donee dies before accepting the gift, it becomes invalid. Additional points. This definition applies to both inter vivos gifts made during the donor's lifetime and testamentary gifts made through a will. Certain types of property, like future possessions or intangible rights, cannot be gifted. There are specific formalities required for gifting certain types of property, like land. Implications. Understanding the definition of a gift is crucial in legal matters related to inheritance, taxation, and property disputes. This definition emphasizes the free and unconditional nature of a gift, distinguishing it from transactions involving payment or exchange. The requirement for acceptance ensures mutual agreement and protects the donor from potential exploitation. Possible questions to consider. What constitutes acceptance of a gift? Are there any exceptions to the requirement for acceptance? What happens if a gift is challenged after the donor's death? I hope this elaboration helps. Feel free to ask any further questions you may have about this definition or related legal concepts. 123 Transfer. How effected? For the purpose of making a gift of immovable property, the transfer must be effected by a registered instrument signed by or on behalf of the donor and attested by at least 2 witnesses. For the purpose of making a gift of movable property, the transfer may be effected either by a registered instrument signed as aforesaid or by delivery. Such delivery may be made in the same way as goods sold may be delivered. Section 123 of the Transfer of Property Act, 1882, deals with the method of transferring property in a gift. It essentially specifies the formalities required to make a valid gift of both immovable and movable property. Let's break it down. Immovable property. For immovable property like land or buildings, the transfer must be done through a registered instrument. This means a formal document that has been signed by or on behalf of the donor, giver, and attested by at least 2 witnesses. The instrument must then be registered with the appropriate authorities to make the transfer official and publicly known. Movable property. For movable property like cars, jewelry, or furniture, there are 2 ways to transfer ownership through a gift. Registered instrument, same as for immovable property, using a signed and witnessed document that gets registered. Delivery. This is a simpler method where the donor physically hands over the property to the donee, receiver. The delivery should be similar to how goods are delivered in a sale, with clear intention and transfer of possession. Important points. The requirement for a registered instrument or delivery ensures that the gift is genuine and verifiable, reducing the risk of disputes or fraud. The specific formalities for delivery of movable property may vary depending on the type of property. For example, transferring ownership of a car might involve handing over the keys and registration documents. This section only applies to inter vivos gifts made during the donor's lifetime. Gifts made through a will follow different rules. Here's an analogy to help visualize the difference. Imagine giving a house as a gift. You wouldn't just hand over the keys, you'd need a formal deed of transfer signed by both parties and registered with the government. This ensures everything is clear and documented. For a smaller gift like a book, simply handing it over is usually enough. Remember, consulting a lawyer is always recommended for complex legal matters involving property transfers and gifts. This information is for general understanding only and may not apply to specific situations. I hope this explanation clarifies the formalities involved in transferring property through gifts under Section 123. 127 Onerous gifts, where a gift is in the form of a single transfer to the same person of several things of which one is, and the others are not, burdened by an obligation, the donee can take nothing by the gift unless he accepts it fully. Where a gift is in the form of two or more separate and independent transfers to the same person of several things, the donee is at liberty to accept one of them and refuse the others, although the former may be beneficial and the latter onerous. Onerous gift to disqualified person, a donee not competent to contract and accepting property burdened by any obligation is not bound by his acceptance. But if, after becoming competent to contract and being aware of the obligation, he retains the property given, he becomes so bound. Illustrations. A has shares in X, a prosperous joint stock company, and also shares in Y, a joint stock company, in difficulties. Heavy calls are expected in respect of the S shares in Y. A gives B and L his shares in joint stock companies. B refuses to accept the shares in Y. He cannot take the shares in X. B. A having a lease for a term of years of a house at a rent which he and his representatives are bound to pay during the term, and which is more than the house can be let for, given to be the lease, and also, as a separate and independent transaction, a sum of money. B refuses to accept the lease. He does not by his refusal forfeit the money. Section 127 of the Transfer of Property Act, 1882, deals with onerous gifts. These are gifts in which property with liabilities or obligations is included alongside other, potentially beneficial, property. It outlines the specific rules governing acceptance and rejection of such gifts. Here's a breakdown of the key points. Single transfer. If a single transfer to a person, donee, involves both properties with burdens, onerous, and those without, beneficial, the donee cannot accept only the beneficial ones. They must either accept the entire gift or reject it completely. Illustration. A clarifies this by showcasing shares in both a good and a struggling company. Refusing the troubled shares means losing the good ones too. Separate transfers. When a series of separate and independent transfers are made to the same person, including both onerous and beneficial properties, the donee has the choice to accept some and reject others. Even if the chosen gifts are less valuable than the rejected ones, the decision stands. This is illustrated in B, where accepting a sum of money doesn't require accepting a burdensome lease. Incompetence and onerous gifts. If a person deemed incompetent to contract accepts an onerous gift, their acceptance is not legally binding. This protects them from potentially harmful deals. However, if they regain mental capacity and choose to retain the property, they become bound by the obligations associated with it. They cannot later claim they were unaware of the burdens when initially accepting. Implications. Section 127 ensures fairness and informed consent in accepting gifts with both benefits and burdens. It prevents exploitation of vulnerable individuals, particularly those with limited mental capacity. The rule of separate independent transfers provides flexibility for donees to manage their obligations. Remember, this information is for general understanding and may not apply to specific situations. Legal consultation is recommended for complex property transactions involving gifts with obligations. I hope this elaboration clarifies the intricacies of Section 127 and onerous gifts. Feel free to ask any further questions you may have. 128 Universal donee. Subject to the provisions of Section 127, where a gift consists of the donor's whole property, the donor is personally liable for all the debts due by and liabilities of the donor at the time of the gift to the extent of the property comprised therein. Section 128 of the Transfer of Property Act, 1882, deals with the concept of a universal donee. This is a special type of recipient who, upon receiving a gift, inherits not just specific property but the entirety of the donor's assets. However, this comes with a significant responsibility. Let's break it down. Key points. All of the donor's property. When a person gives away their entire estate to one individual, that individual becomes a universal donee. Liability for debts and liabilities. With this inheritance comes personal liability for all the debts and liabilities the donor had at the time of the gift. This includes, but is not limited to, outstanding loans, unpaid bills, and legal obligations limited by the value of the property. However, the donor's liability is not unlimited. They are only responsible for the debts and liabilities to the extent of the property they received. Subject to Section 127, this provision applies subject to Section 127, which deals with onerous gifts. This means that if the entire estate includes both beneficial and burdensome assets, like a profitable business and a heavily mortgaged property, the rules of Section 127 regarding acceptance and rejection might come into play. Implications: becoming a universal donee involves considerable responsibility. They inherit not just assets, but also all the financial obligations attached to them. This concept can be useful for ensuring the smooth transfer of an entire estate and avoiding legal complexities during inheritance. However, it's crucial for both the donor and the donee to understand the legal and financial implications before entering into such an agreement. Example: imagine Mr. X owns a house, a car, and has some outstanding debts. If he gives his entire estate, including both assets and liabilities, to his daughter, she becomes a universal donee. She would inherit the house and car but also become personally responsible for repaying Mr. X's debts, up to the total value of the inherited property. Remember, consulting a lawyer is essential when considering a universal gift due to its complex legal implications. This information is for general understanding and may not apply to specific situations. I hope this elaboration clarifies the concept of a universal donee and its associated responsibilities. Feel free to ask any further questions you may have.